To confirm some judgments.
Well, and you know what?
My phone on
That
mute.
screen gonna be turned this way?
It will be.
I like that screen. That's nice.
Very helpful. This meeting of the State of Rhode Island Board of Elections will come to order. It is Wednesday, August 3rd. It is 2:02 PM. Madam Secretary, will you read the roll, please?
Thank you, Madam Chair. Chairwoman Maderas.
Here.
Vice Chairman Pierce.
Here?
Member Betancourt. Member DeSimone.
Present.
Member Johnson. Present. Member Scholl. Present. Member West.
Present.
Executive Director Robert Rakota.
Present.
Legal Counsel Ray McCarthy.
Present.
Thank you, Madam Chair.
Thank you, Madam Secretary. Here, we're getting a little feedback. First item on today's agenda, the board may discuss and vote to approve the minutes of the meeting held on Monday, July 25th, 2022. Do we have a motion to approve the minutes?
Second?
Moved by Mr. Scholl, seconded by Vice Chair Pierce. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed?
I'll abstain, Madam Chair.
We have 2 abstentions and 4 ayes. Second item on the agenda, the board may vote to meet in executive session pursuant to Rhode Island General Laws 42465 subsection A4 and 17255 subsection A7I to discuss and/or vote on a campaign finance investigation in one campaign finance matter. Do we have a motion by the board to go into executive session? Moved by Mr. Scholl, seconded by Mrs. Johnson. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Opposed? We will go into executive session at 2:03 PM. And please note that Marcella Bettencourt is now present. Okay.
Okay.
Very good, very good. I stabilize myself.
Yeah.
I don't.
Oh, yeah. If you'll ever go.
Like they do. But I can go a
Good for you. Good.
It's more now upper body strength, but,
Yeah.
you know, as long as I can
Yeah, oh, good, yeah, that's good.
4 or 5 strokes, get to the hole, I'm happy.
Yeah, oh, yeah. It's just being out and being with other people and people you enjoy being with.
Oh, yeah, yeah, yeah.
Yeah.
Guys I work with, you know, and we have war stories and you know.
Oh, yeah. How often do you play?
It's just to be able to
Yeah. How often do you play?
play once a week, play Tuesday.
Yeah, good.
That's it. Well, Tuesdays.
Yeah, that's gonna be, that's gonna be the one she does.
There you go. You keep things in perspective.
Today, nice and cold.
Yes, Madam Chair.
I'll entertain a motion to resume open session and to seal the minutes of the executive session.
So moved.
Moved by Mr. D. We have a second? Second by Mrs. Johnson. Any discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed, unanimous. Mr. Mercatio, would you like to
Yes.
report?
Thank you, Madam Chair. There's one matter to report out from the executive session. It involves Ramon A. Perez. Mr. Thornton, the Director of Campaign Finance, presented the results of his audit of the campaign finance reports of Mr. Perez, and then recommended the entry of a consent order. Board Member Johnson then moved to adopt the consent order, seconded by Mr. Scholes. All 7 board members voted in favor, none opposed. That's all, Madam Chair.
Thank you. Item number 3, the board may discuss and vote to approve the finalized rules and regulation for relocation of polling places. Mr. Mercatio.
I believe these are all being continued, is that right?
Number 3 is not.
Okay,
Number 3 is the relocation of the polling places.
okay. All right. And do we have the highlighted changes?
You have, there's 2 documents, 3A and 3B. 3A is the one that was posted on the website. 3B is the document that has been changed by staff, Mr. Mercatio.
Changed and also advertised, correct?
And it has additions.
I don't have that as part of my packet.
So the blue copy, Madam Chair, is the original, is that my understanding?
That's my understanding.
The blue.
And then
With the
the
changes.
black copy
Yeah.
with the red indicators is the actual, we'll call it the proposed final copy.
Exactly. And these changes in red were changes that were proposed by our board members.
Incorporated by, Attorney Mercatio made the
Okay.
changes to.
Past the
3B.
public comments?
Created
Okay.
3B.
This one? Okay, all right. Thank you. Madam Chair, there were several changes that were suggested, both by board members at 2 different open meetings, as well as by board staff. You'll see that on page 2 of 3B, there was a change that indicates that the notice of the hearing would be posted on the municipal website and submitted to the local news media outlets whenever possible. Another change, this one I recall was made by Mr. DeSimone, is on number 4 on page 2, suggesting that the term must be changed to shall. With respect to number 5, 1 or more members of the board sought to have the Notice for the posting be up to and including Election Day, which is reflected in red. And then we made one change noting it was at both the previously approved polling place and the new polling place. There was a suggestion that the reference to day be clarified that it would be a business day as opposed to calendar day, and that is likewise found in number 5. I remember Mr. Brown from the ACLU questioned whether the language would have to be, when it said by community, what exactly that meant. So I deleted that reference to community and have it for the polling place. So whatever the ballot looks like at that polling place is likewise what the notice. So if it's in Spanish as well, then the notice likewise has to be in Spanish as well as English.
Very good.
Number 6 just clarifies that when there's going to be a relocation of the polling place, and there's going to be notice of that it go out at the direction of the local board. And that would go to each qualified voter of the affected voting district. Finally, on the last page, there was some discussion at 2 different meetings as to how we could reference the use of the meeting and whether it would be done by emergency and under what conditions. You can see that we deleted both one suggestion, which was impossible to meet under the circumstances, the OMA requirements, and then extremely difficult to meet the obligations under the OMA. That likewise was suggested to be changed to just difficult, and that's reflected in this version. Those are the additional changes that were suggested over time, apart from what you already have that's been posted with the Secretary of State's office.
Thank you, Ms. Marcaccio. Any comments, questions by any of the board members?
Oh, Madam Chair. Just a
Mr.
question.
West?
Well, when it gets to the local board, actually, in front of us, what amount of time do we have before we get this, listen to this, a petition? You have an election coming up. Is it 2 weeks before, month before, 5 days before, 1 day before? You know, because I remember what we had from, was it Lincoln? Woonsocket, right? And it was at the last minute. And really did not have enough time to digest what was going on, and we had to make a decision right then and there. It was within, say, 2 seconds of the date of voting. So I'm wondering, should there be something in there where, I mean, unless an emergency situation comes up, but under normal circumstances, that we should be given at least a 2-week notice as to what has been done. You know, what the local boards have decided for a new voting for a particular district.
We could include that if the board wants that to be included. It does give us a little more definity, but it does, if there may be some circumstances where less than 2 weeks, if we're notified, and it's a possibility to notify the voters in the polling places, that we could do it. That's why I believe it's open-ended as it is. And it is clear in here the timing. The local board hearing shall occur as reasonably possible after the relocation becomes necessary. And then it's approval of our board, which is number 4 under 26.4A.
So
A4.
I'm just wondering if, you know, for our benefit, because, go ahead.
No, I was just gonna, off that question, I was just gonna ask Ray a question. So Ray, in the event that, as the commissioner stated, the board felt that there was not a viable enough time to notice people, regardless of what the local board said, we could deny them the request to move the polling place, correct? On that basis?
That's correct. I mean, the regulation is designed to primarily deal with those instances where there is some type of emergency or the building is no longer available. Now, what Mr. West said, the only concern I have with that is possibly telegraphing to the local boards that they could sit on information about the unavailability of a building until 2 weeks beforehand, thinking they've satisfied the reg, the Board of Elections only needs us to give 2 weeks, and that would not give the local community all the time that it might have to notify everybody of that change. So I think if we use a reference to any specific time, it does give me concern because it just may telegraph the wrong message to the local communities. But I also understand your concern because it was what really generated the need for this regulation in the first instance, that possibly a local community knew of a need to change, but didn't do so as timely as it could.
That was my
It is a
concern.
problem. Yes, Mrs. Johnson, you had a question.
Thank you, Madam Chair. Building off of that further, it's, it's it says emergency, and I remember having this discussion, but we struck impossible and extremely, and it says difficult. So to your point, I just worry that people might sit on it a little bit longer. So I wonder, those two seem a little bit in conflict, but I don't remember the exact, I think Commissioner DeSimone, you were the one that.
I had the original concern, yes, because I'm looking at it from the standpoint of if this board found that it was A, not an emergency, or B, that the locality had notice and just decided to sit on it, then this board could deny the request to change the polling place. Is that correct?
So long as
Ray, or-
well, I guess it would depend on the circumstance. If the building is not available, that's
Yeah, There'd be
different.
no choice, yeah.
No
Right.
choice.
Yes, and-
I mean, typically they're changing these. Remember, this is after everything's already been designated. Something's gone wrong and it's either a water main breaking right before the election. They can't satisfy the OMA. They've got to meet right away, get a new place, notify us. Or it's something like either the building is not accessible, handicap accessible, and that was determined later. The building is not accessible due to the landlord saying it's not. I mean, there are a number of things that this regulation contemplates that don't really easily fall within a 2-week period, 60-day period, which I think at one point was considered. So that's my only concern about putting a deadline. It should be something more along the lines of with as much notice as possible so that if, as Mr. DeSimone said, we determined that they sat on this and we determined that it could be used, nonetheless, it's just a matter of preference, or I think you would deny it because
So
they
where
sat
would
on
you,
it.
where would you propose to insert that language?
to the-
And
to the-
I must say that, I would think that the local boards would really try not to have to do this because it is a real problem for them. And just the notice to the voters is difficult. So I know it's not something that they would do willingly.
I mean, we have under number 3, the local board hearing shall occur as soon as reasonably possible after relocation becomes necessary. I mean,
Right, through the chair.
Yes,
the-
Mr. West.
The real concern I have is that to try and keep a new voting building within the district itself before going out of the district, that every attempt will be made possible to keep it within the district. That's my main concern here. And only if it, no matter what, they can't find another location, then they have to go out of district. But to try and maintain the voting location within the district that it's in now.
Well, I think the language in 26.41 subsection B there is pretty clear that it would only be upon a majority vote of the local board to allow that, right? To allow them to move it not within the district. And it would require approval by us anyway, that this is
That's
a
right.
suitable location. So I think we have some protection there.
Okay, all right, all right, I'll defer to that.
Any other comments or questions?
Yeah, I mean, the only other comment I would make is if the board feels that there should be some time period on the timing, because of the comments that we just had. I don't know whether the board thinks the local board should be noticing us in a particular window of time
Do you
from
have,
when they get noticed.
do you have a suggestion?
I don't.
I'm
I just-
hoping.
I'm throwing out the question. You know,
I mean, perhaps what
I
the
would think
board,
within a couple of business days, we should be made aware of
Of
it.
them being aware,
Sure.
maybe, yeah.
And I don't know if that makes the board members feel better, or, you know,
Or
at
then,
least we would know.
yeah, or then what we could vote is just vote to approve this as it is now, see if anything down the road comes up where
We need to modify.
we need to
Yeah.
change it.
That's
And
a
then,
I'd be okay with that,
That's a
yeah.
great idea.
Sure.
That makes sense,
Yeah,
Mr.
that
West.
makes sense.
Okay, any other comments? What is the board's pleasure with reference to this rule and reg?
I mean, I'll move to adopt it.
and Mr. DeSimone, I suggest that you move to adopt it with the proposed changes, if that is the wish of the
Yeah, I'm
board.
actually going to make the motion to move to adopt what we've designated as 3B, which is the document that I think I have with all the changes in it.
And I will second that motion.
Moved by Mr. DeSimone, seconded by Vice Chair Pierce. Any further discussion? Hearing none, all in favor signify by saying aye.
Aye.
Those opposed? It's unanimous vote of the board. Okay, items number 4, 5, and 6 will be taken up at the August 16th meeting of this body. I believe we're still getting public comment with reference to number 4, and we're moving number 5 and 6 as well.
Correct.
So we're on item number 7. The board may vote to hear objections to the nomination papers that have been filed in accordance with the requirements of Rhode Island General Law 1714-13 and 1714-14. Mr. Reposa.
Good afternoon, honorable members of the board. I would like to begin this agenda item by providing you with a brief summary of the events which brought this item before you this afternoon. 1714-1, Rhode Island General Election Law, Declaration on Candidates states, on the last Monday, Tuesday, and Wednesday of June, which this year were June 27th, 28th, and 29th, the declaration period for 2022 was open, and it closed at 4 p.m. on Wednesday, June 29th. Candidates for General Assembly, state offices, statewide offices, Senate, or representative committees, or for local races must declare for candidacy at the local board of canvassers, which the candidate is a registered voter. Statewide offices, general office and congressional candidates must file at the Rhode Island Secretary of State office. Per statute 1714-4, the preparation of nomination papers for candidates states within 2 business days after the close of the declaration period, the Secretary of State for statewide candidates and local board of canvassers for General Assembly and local candidates shall prepare 3 sets of nomination papers for each candidate. Nomination papers were issued to the candidates beginning Wednesday, July 6th. Per statute 1714-8, the signing of nomination papers states that endorsers, who are voters, must sign in person his or her name, place of residence, and street number as it appears on the voting list. The signature shall be accepted as valid if it can be reasonably identified to be the signature of the voter it purports to be. The endorser must sign on the nomination paper that has been designated for the city and town in which the endorser is a registered voter. Per statute 171411, checking and certification of nomination papers states all completed nomination papers must be turned into the respective city or town 60 days prior to the primary, which for 2022 was July 15th at 4 p.m. Per statute 171412, filing of nomination papers states that all nomination papers for state offices and all certified lists for local offices shall be filed at the office of the Secretary of State no later than 6 days after receipt by the local boards of canvassers or 54 days prior to the statewide primary. Per statute 171413, objections to eligibility of candidate or sufficiency of papers state that all nomination papers duly filed are in apparent conformity with Rhode Island General Law 171411 and presumed to be valid unless written objections to them are made as to the eligibility of the candidate or the sufficiency of the nomination papers for the signatures on them. All objections must be filed in the office of the Secretary of State for state or local boards, as the case may be, by 4 p.m. on the next business day after the last day fixed for filing nomination papers in the appropriate office. Per statute 171414, hearings on objections. Witnesses. Notice states that all objection to nomination papers which are required to be filed with the Secretary of State shall be considered by the State Board. The Secretary of State is required to deliver the original nomination papers to the State Board. 171414 is ultimately the section of Rhode Island state law that brings these issues this afternoon before you. We have two candidates that we will present to you. The first one is an independent candidate for representative in Congress, District Number 1, Jeffrey Lemire. Mr. Lemire, as a candidate for this office, was required to obtain 500 valid signatures to be considered for placement on the Tuesday, November 8th, 2022 ballot. The second individual coming before you this afternoon is Libertarian candidate for Rep District Number 5, Cory Vecchiarino. Mr. Vecchiarino, as a candidate for this office, was required to obtain 50 valid signatures to be considered for placement on the Tuesday, November 8th, 2022 ballot. The third candidate on today's agenda was referenced previously by Chairwoman Medeiros, the Libertarian candidate for Governor Paul Riani Jr.
He's an independent candidate, he's not.
Yes, you are correct. I'm sorry. Independent candidate Paul Riani Jr. He came into the office yesterday and requested that you not hear his objection today because he could not be in attendance. I asked him if he could be here for August 16th at 2 p.m. He told me he could not because he was going to bring a witness, and the witness was not available on that day. I asked him to let me know as soon as possible as to his availability to bring this issue before you.
Sure, because there's a deadline, right?
These are for November ballots.
Right, I know.
At this time, I would like to turn the remainder of this agenda over to Deputy Director of Elections, Miguel Nunez, who will present the staff certification of the two candidates before you today. Madam Chairwoman, if you could please swear in Mr. Nunes.
Would you please stand? Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Please be seated. We'll hear from you, Mr. Nunes.
Good afternoon, members of the board. At this time, I will proceed with presenting to you the review that the staff has conducted for each of the candidates in question today. For the benefit of those board members who are not present at the last meeting that this was presented for other candidates, I'll provide a brief review of how I will present the information. First, I will provide a summary of the number of signatures that the office requires, which Bob did go over for both candidates, the number of signatures that the candidate submitted, the number of signatures approved by the local board of canvassers, and the number of signatures disqualified by the local board. I will then break down the number of disqualified voters into the various reasons. If the Board of Elections found that a voter should not have been disqualified by the local board, I will indicate the reason for those for those disqualifications, and those signatures would be available for you to review today. I'll also mention that both challenges being reviewed today were filed by the actual candidates themselves because they were disqualified from being on the ballot due to the number of signatures being certified being less than the required number. So the first candidate we'll review is Jeffrey Lemire, an independent for Representative in Congress, District 1. This office requires 500 signatures. The candidate submitted 566 that were certified by the BOE staff. 453 of those signatures were approved. 113 were disqualified. The disqualifications were broken down to the following categories. 5 voters were in the wrong district. 2 were incomplete entries. There were 0 duplicates. 88 voters were not found to be registered, and 18 signatures are available for you to review today if you choose to do so. 6 voters were actually found by the BOE staff, so the actual number of signatures that the Board of Canvassers disqualified was 12, but we actually found 6 in our research that the signatures were not reviewed by the local board because they did not find them as voters, but we did find them. So those would be available for you to review today in addition. Just for informational purposes, when we do this review, our staff has the ability to search for voters by partial first name, partial last name. They can put in an address into the central voter registration system, determine all the voters registered at that address. We can look for all voters of a particular date of birth. I mean, we have a lot of ways to find voters, so we use all those methods, and that explains why we're able to find voters in some instances where the local boards cannot. Although they do have that ability too, they're also under a time constraint, as Bob mentioned, of the 6 days where they have to get those signatures to the Secretary of State's office. This candidate does need 47 signature qualifications to make the ballot. However, we only have those 18 signatures for you to review here today. So if you were to approve all 18 signatures that we are prepared to present to you for review, the voter would still fall short of the 47 that they would need to qualify for the ballot. So if you would like me to present those signatures, I am prepared to do so. We're ready to present them if that's what you want to do.
I had one question on that first, Miguel. When you say there were 18, so your parenthesis is saying 6 voters found. Is that part of the 18?
Yes,
Okay.
correct.
And is the candidate here?
I am candidate.
Okay. I think it would be appropriate to swear him in and hear if he has any other.
Actually, right, he just presented evidence that I wasn't even given. So if I could actually see his 18, that I can cross-reference with what I'm trying to object to, because what I'm totally bewildered by what he just did, because I was not given any of this for the last 7 days. So he's giving you something that I haven't been able to look over. So if I could look over his 18 signatures and I can see what town they came from, then I can see what my objection would be. Okay?
Could we have a member of the staff, Miguel,
We can, yes.
meet with this gentleman? Yes, Mr.
Madam Chair,
Dufresne?
I just have a question from Miguel. So you're actually adding 18 signatures to his count?
No, there were 12 signatures actually disqualified by the local board. So those you would have to review regardless, but we found the extra 6 who were disqualified because the voter was not found by the local board. So they didn't even look at the signature because they couldn't find the record. We found the record, so you would have to review those 6 in addition to the 12 that they've already reviewed. So there are 18 signatures for review. Every other voter on this, on these nomination papers were either not found or they were in the wrong district. They signed in the wrong district.
So if we were to approve the 18 signatures that have been disallowed,
Correct.
Well, there were
We would
12
have-
that were disallowed, right? And then you found, or there were
12 disallowed for signature purposes.
Yeah.
But 6 of them were disallowed because they were not found. The record was not found.
and then you found.
Yes.
You found them.
So there are
if-
18.
I guess my question is, if we approve all 18 of those, we say all 18 of them are good.
Mhm.
The local board said that 12 of them were not good, correct?
Correct.
If we give the candidate the benefit of the doubt and call all of those signatures good, we don't consider them at all, where does that leave him in the nomination process?
He would still be short 39 signatures.
So to go through all of those 18 signatures is in effect an exercise in futility. Because I would be prepared, excuse me, sir, I would be prepared to move all 18 signatures as good.
Yeah, excuse me, it
At
would be
this point.
29 short.
And I would call all 18 signatures good, giving the candidate the benefit of the doubt. Rather than have to go through each individual signature, if the board determines that they're good, where does that leave us?
Mr. DeSimo, before that motion is made, may I?
No, I'm not, I'm just
Oh.
asking the question at this
Yeah.
point. I'm not moving it. I'm asking the question. If there are 18 signatures that we're going to
It's-
be, that he's going to be challenging, so to speak, to say they're good, that's fine. And I'm more than willing to let the candidate do that.
Yeah.
But I just want to make the candidate aware of the fact that he doesn't just need those 18 signatures. You need more than those 18
And I
signatures.
think he does know that, looking at this board here, but what were you going to say?
Well, my question though for the candidate is, do you have any other challenges separate from the signatures? For
I have
example,
challenges in North Providence, but this is the thing, I have to see what his 18 are, so I can decipher them. So my thing, all I want to see is what his 18 are, and then we can get right back to this.
you're saying you may have others that are not in
Oh,
that
yeah,
list.
no, I'm actually challenging, let's see, I'm challenging 3 from East Providence, because they wouldn't take them because they weren't notarized. And when I got there, they wouldn't notarize no papers. So they refused to take 3 signatures from East Providence, it's only 3. Then I have 2 from Cumberland that they denied because of the signature. Now, I don't know if he has
I
that,
see.
those 2 there. I have 49 that I'm challenging from Lincoln. I don't know what he did with those. So like I said, he's telling you something right now. I can't see what he's offering. So if we can have 5 minutes when he could just show me the evidence that he just gave you, that he didn't give me prior to this hearing. Okay? That's
So,
where I'm at right now.
Mr. Mankashi, I think at the last meeting, we did allow for a meeting privately so that we
Yes.
could sort some of this out. So I think we should probably try to do that and maybe take up the next case
That's fine,
while
Madam
that's
Chair.
happening.
I'm still unsure as to what the other challenges are based on, whether it's the voter not found or 5 in the wrong district, but I think perhaps that could be
So I guess-
addressed when they reconvene.
I guess what I would, and I'm only one member of the board, what I would request that you do, sir, is there were 113 were disqualified in total. Okay, what I would suggest, once you meet with our staff, and I don't know if it's going to be Miguel or someone else, but once you have your meeting, I would suggest that you need to look at the ones that are disqualified and tell us why they shouldn't have been
Yes,
disqualified.
exactly.
Okay.
That's my legal point here.
And you're more than entitled to do that.
It's gonna come, so.
Okay.
Like I said, just need 5 minutes, he just shows me the ones that.
Okay.
Was 18, and if they came from certain towns, then we know what he did.
We understand.
I'd also like to point out that the candidate did not request this, copies of these from us previously, and I don't believe the Secretary of State received a request, but Rob Rock is here. In previous instances, candidates have been provided copies if they've requested them. We didn't
Understood.
receive such a request.
We understand. Is it possible for someone in your staff to meet with them, or would
Sure.
or would you recess, or how are we going to handle this?
Madam Chair, are you going to take up the next matter?
We are.
Okay, I am going to have to recuse on the Representative District 5 race. I have a relative that's running in the Democratic primary in District 5, so I don't feel that I can. sit
Understood.
on that.
So for the record, Mr. DeSimone is recusing himself from participating in the discussion or vote concerning Mr. Vecchierino?
Vecchierino?
Yes. Very good.
So the review that we conducted for this candidate, who is a Libertarian candidate in Representative District 5, which is in the city of Providence. This office requires 50 signatures. The candidate submitted 88, and those were certified by the Board of Election staff. 39 of those signatures were approved, 49 were disqualified. The breakdown for the disqualification is as follows. 24 were in the wrong district, 0 incompletes, 1 canceled, 22 voters were not found, and you have 2 signatures for review today. One of those signatures was actually a voter that the Board of Election staff did find upon our review. So we did include that in your signature review. So 1 signature was disqualified by the Providence Board of Canvassers. The other was found by the Board of Elections staff, which the Providence Board had originally disqualified because they could not find them. This candidate does need 11 signature qualifications to make the ballot. However, as I mentioned, we do only have 2 signatures eligible for review. I will note that this district is only obviously a part of Providence, and many of the voters who were disqualified, as you can see, because they were in the wrong district. So it's very easy for voters to be assigned a paperwork when they actually live in a different rep district. So that's why we
Understood.
noticed that number.
Miguel, what is incomplete? I mean, what is canceled? What does that mean? When was
Canceled would mean that the voter has been inactive for a certain length of time, or they may have actually requested that their voter registration in writing be canceled. And they would actually go into a canceled status within the CVRS.
Okay, thank you. Board members, any questions for Mr. Nunes regarding this case? Mr.
Has the candidate been informed about the wrong district disqualifications?
To my knowledge, we haven't received a request from the candidate for copies of these documents, and I do not believe the Secretary of State has, but those copies of the nomination papers are available for the candidates to review prior to this hearing.
Is the candidate here? Oh, he's here.
My name is William Hunt. I'm the chairman of the Libertarian Party. I'm on the agenda for the next item, but I did speak with the candidate before this, and for what it's worth, he found 2 as well, so I don't think there's going to be much of an objection to this, so.
All right, thank you.
Thank you.
So as I mentioned, this candidate does need 11 signature qualifications to qualify for this ballot, and you only have 2 signatures to review. However, we are prepared to present those signatures to you if you choose to review them.
What's the board's pleasure with reference to this matter? Did you want to review them?
I mean, it's still, I guess, it's the matter of something.
Well, in fact, even if we approve those 2 signatures, the candidate would still be eligible to be on the ballot. So I would move that we deny the appeal.
Moved by Vice Chair Pierce. Do we have a second? Second by Mr. Scholes. Any other discussion? Hearing none. All in favor signify by saying aye.
Aye.
Opposed? It's unanimous.
Do you want to go to the last one?
Yes, can you please get Mr. DeSimone?
On my way.
Thank you. We think Mr. Lemire is going to be tied up for a bit.
There are 18 signatures to review, so that might take a few minutes
Yeah.
and if he's objecting to any of the others,
It could take a while.
yes, but he only mentioned these signatures, which we do have highlighted, which are easily identifiable in the documents that I gave him.
But even if they were approved, he'd still be short.
objections are.
It must be Rhode District or something like that.
Can I go to number 8?
So we have Mr. DeSimone back. And we will take up item number 8 while Mr. Lemire is having his meeting with the board staff. I know. Item number 8, the board may vote to hear a complaint filed by William J. Hunt Jr. regarding the certification process and the nomination papers submitted for Elijah J. Gizzarelli, candidate for the office of governor. Are we going to hear from you?
Thank you, Madam
Mr.
Chair.
Mercutio?
I believe Mr. Hunt is here. If you could approach, and I think we should swear
Be
in.
sworn?
Yes.
Mr. Hunt, would you raise your right hand? Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please be seated.
And you've already indicated that Mr. Vecchiarino is not here, but what about Mr. Gizzarelli, the candidate for governor?
No, both candidates work and were unavailable for the time today, so I'm here on their behalf.
And you are not an attorney, correct?
No, sir.
Okay, I think, Madam Chair, we should hear from Mr. Hunt. It's a lengthy complaint, but if I could just take a moment to
Please.
frame the issues for the board. Present before the board is a filing by Mr. William Hunt Jr. on behalf of himself as a voter, on behalf of the so-called Libertarian Party of Rhode Island, to which he has asserted that he is the chair, as well as on behalf of Elijah Gizzarelli, gubernatorial candidate, again for the Libertarian Party of Rhode Island, and Mr. Corey Vecchiarino, again a candidate from the Libertarian Party. At this point, the Libertarian Party of Rhode Island has yet to be recognized under Title VII, Chapter 1 of the general laws by having a candidate for a governor that could, of course, satisfy that depending on what percentage of vote that person receives. The filing by Mr. Hunt is basically in two parts. The first part is akin to what we have been dealing with today as well as at our last meeting. Namely, challenges under Chapter 14 of Title 17 regarding the actual nomination papers and supposedly one or more signatures or notary provision for those nomination papers. Those are the focus on Mr. Gizzarelli, who is the gubernatorial candidate. The other part of the filing, which is the vast majority of it, sounds more as a complaint, and you can see as you read the papers that it goes from a challenge, and then as you get at least to the second page and thereafter, Mr. Hunt refers to all of his allegations as part of a complaint. Those complaints are apparently on behalf of Mr. Gizzarelli, on behalf of Mr. Vecchiarino, and perhaps on behalf of the party itself that is attempting to be recognized as a party in the state of Rhode Island. The allegations are varied and broad. They include claims that the entire processes used for the nomination papers being filed, counted, is improper, that it serves in some way as a barrier to the ability of the candidate to gather the signatures. And Mr. Hunt is here. Of course, anything I say where I have summarized it is my summary. And he, of course, can correct me, and we should give him an opportunity to clarify. It also makes allegations that perhaps one or more state or local agents may not have satisfied all of their obligations. It indicates in part that if you look at it statistically, there may be evidence that given the disparity between the number or percentage of signatures that were accepted in one community versus another, that perhaps there is some arbitrary or subjective component to the acceptance of certain signatures. And possibly more, and again, Mr. Hunt can clarify. All of those allegations, which are basically a complaint, in my opinion, Mr. Hunt does not have standing to bring those claims, which are legal challenges, on behalf of anyone other than himself. So of course he can do so pro se. But if it's on behalf of Mr. Gizzarelli, on behalf of Mr. Vecchiarino, on behalf of a entity that he is referring to as the Libertarian Party, it's our practice, since we're a quasi-judicial agency, to require that a member of the bar represent third parties. So in my opinion, with respect to the complaint aspect, I do not believe he has standing to bring this representing others, third parties, that are not before you here today. My opinion to the board is different with respect to the first part of this, under the challenges. Under Chapter 14, while there isn't a specific reference to this under 17-14-14, I do recall that in previous sections, mostly dealing with nomination papers that will be reviewed by local boards, I think that's 17-14-11, that it does reference those people who can bring the challenge. It references the candidate. It likewise references the chair of a party committee. Again, Mr. Hunt is not the chair of a recognized political party, but in my opinion, the board should be liberal in its granting of standing on the aspect of challenges to the nomination papers, given that 17-14-14 just refers to political parties. It doesn't say recognized political parties or not. Other chapters in Title 17 do so. I believe chapters 19, chapters 26 do refer, the General Assembly has on occasion referenced political parties as those that are recognized. So it's clear that the General Assembly knows that when it wants to limit it to recognized ones, it can do so. So for all of those reasons, I believe that Mr. Hunt should be allowed to present any challenges that they have with respect to the nomination papers, specifically the signatures that have been presented. And my opinion to the board is likewise that with respect to the balance of the claims, those be denied without prejudice, given that he, in my opinion, does not have the role or the standing to bring those claims on behalf of others.
Thank you, Mr. Marcaccio. Do the board members have any questions of our legal counsel before we proceed? Okay, we will hear from you, sir.
Thank you, Madam Chairwoman. I appreciate you taking the time to hear this complaint and the challenge as well. As the legal counsel clearly played out, I am not, in fact, an attorney. I am the chairman of what we are trying to attempt to form the Libertarian Party of Rhode Island here in the state of Rhode Island. Obviously, there is a process that goes along with that. And a lot of what we're running into here is a chicken and the egg type situation, similar to what was described, where we are unable to act in the official capacity of a legal party in the state of Rhode Island because we are not, in fact, one. Yet we are expected to follow all the rules and regulations of a party when it comes to finance, when it comes to getting candidates on the ballot. And part of what our goal is in order to become an actual recognized party in the state is to run, as prescribed by statute, to run a candidate for governor, declare that we intend to form and establish that political party here in the state, and then hopefully get the 5% requirement, which would allow us to then be recognized and hopefully maintain that going forward. This was an exercise of our attempt to do that. I will try my best to divorce the two issues of this, even though they are related. The one being us trying to form a political party, which obviously is something that is a limited window is given to us once every 4 years, once every 2 years, potentially if you count the presidential election, to get party status here in the state of Rhode Island. So we have a limited time frame, 9 days, in order to get the 1,000 signatures, which is the prerequisite to get that candidate on the ballot. So a lot of what my complaint was the unfairness, in my opinion, of the process that has been laid out in order to us to get actual party status here in the state of Rhode Island. So I understand the point made that, again, I don't have the ability to represent other people, or third parties, which I'm not attempting to do in any way. I'm just here to, again, represent the interest of the Libertarian Party in the form that it is now, which is, again, it's a nonprofit corporation in good standing with the Secretary of State in Rhode Island. And we are also a recognized political action committee, which is in good standing here with the Board of Elections Campaign Finance Division. We have been formally organized, I believe, since 2010 as a nonprofit, and 2017, 2018 as a political action committee. And we've run candidates before. We've attempted to follow the process. That's what we did with this exercise. And really, you know, the frustration that I had with the process and the issues that we ran into, I think, you know, may not be the purview of this board, but I think it's important that we at least get the information out there and people understand the difficulty. If we do want to attempt to change these ballot access laws, we need to petition the General Assembly, we need to petition elected officials. Ideally, we would be able to elect our own candidates to do that, but in absence of the burdensome campaign finance laws, we're attempting to make this known so we can hopefully get some traction. And if we don't get the satisfaction we want this time around, it'll be hopefully a more reasonable process in the next attempt we make. So I do have a number of specific challenges for signatures. I don't know if they have prepared similar, you know, a format as they did with some of the other challenges. I'm not sure exactly what you would be looking for. What would you like me to address, in what order, or what would be the pleasure of the board?
Okay, well, first of all, thank you for your testimony. We appreciate that. And, you know, I understand what you're saying. Does the board have any questions of this gentleman before we proceed?
I have a couple of questions.
Go ahead, Mr. Scholes.
Okay, are you familiar with the state statutes regarding political parties?
Vaguely, as familiar as I can be. I'm not versed in it.
Yeah, because I'm looking at section 17-1-2, which defines a political party or party. And they're one of three categories. If you meet any one of these three, you can qualify as a party. The first is to getting 5% of the votes cast in that state for governor. Okay. Two is you get 5% of the vote of in the race for president. Okay. Or third is it says, quote, any political organization which on petition forms provided to this chairperson of the organization by the State Board of Elections obtains the signatures and addresses of that number of registered qualified voters equal to 5% of the entire votes cast in the state for governor or president in the immediately preceding general election. So there are three ways one can qualify basically as a political party in the state, according to the statute. Okay. So my question is, did you indicated that you didn't get the 5% for those people cast for vote for governor or president, correct?
So we have run presidential candidates in the last, I can't remember, the most recent memory, we've had presidential candidates. The highest we've got in recent memory is about 3.5% with Gary Johnson in 2016. And I think the other part of the statute you just referenced, there's a signature component where we can try to obtain 5% of the signatures cast for the respective party over an slightly longer extended period of time. However, that, again, the sheer numbers of signatures that actually works out to be makes that, you know, a virtual impossibility for such a fledgling organization.
I know, but other parties have done it, but the question is, you have not done that.
With all due respect, sir, I understand your contention that other parties have accomplished this. However, I will mention that two of the times it has qualified, a third party has qualified in the state, has been with the same candidate, Bob Healy, once with the Cool Moose Party and once with Extended the Moderate Party. The cult of personality of a single a candidate does not make a political party. You need to have a functioning ground game and field team that you can support and actually run to have a legitimate function as a political party. The other candidate to do it was Ken Block when the Moderate Party initially did it. Again, he had his own particular cult of personality. He also had the financial backing and the check to write to not only fund his campaign, but also to pay petitioners to get the signatures for him to get on the ballot himself. And again, I think that flies in the face of the spirit of what a political party is supposed to be. We're not supposed to be a top-down organization. We're supposed to be a organization that's building consensus amongst members of the community and putting a platform available that people have the choice to vote for. And trying to encapsulate that with one person in one race in once every 2 or 4 years, I don't think is necessarily a effective way of doing that.
Well, I understand what you're saying, but the point is, the statute does require 5%. We could only look at the statute.
Understood.
Okay.
I would also put out too that the statute was written by the Democrat and the Republican candidates that were elected to those positions. Both have a vested interest in keeping third parties out of the political arena just by the nature of them being in the position that they are.
But you understand the Board of Elections has no authority to change the law.
Understand
It is,
that. And that-
it is as written.
And I appreciate that. And again, that's why I'm trying to relate. I do appreciate the fact that these are two separate issues, and I don't want to conflate the two because I do understand. But again, I do think that it's an important, information to get out to make people aware of the difficulties it is, not just to run a candidate, but to actually form a political party here in the state of Rhode Island.
Okay, there were a couple of other requirements for a political party. One is to file rules and regulations with the Board of Elections. Have you done that?
So
Your party done that?
I cannot tell you whether or not we have filed those rules with the Board of Elections. We do have a set of bylaws that have been operating on every year we have an annual convention where we update our bylaws to the members of the committee. We have filed every single piece of information that the Board of Elections has required us to file to operate as a political action committee. The fact that we're barred from forming an actual political party in the state of Rhode Island prevents us from even being entertained filing the forms that you're.
Yeah, I know, but the statute says 1712-2.1, that political parties must file certified copies of rules and regulations with the Board of Elections. So I take it your party did not do that, correct?
I can't tell you whether or not that has been done. We have to check with our secretary.
And you indicated that you're the chair of this party. Have you your party made any endorsements of your candidates?
I'm sure you're aware of the requirements of a political action committee participating in an election cycle. We are required to endorse a minimum of 3 candidates in an election cycle in order to participate in that election cycle. In the nature of having us being disallowed from forming a political party here in the state of Rhode Island limits our ability to generate candidates and actually have them run as libertarians here in the state of Rhode Island. It has been a long time. I believe it was 2016, the last time we actually had 3 qualified libertarians on the ballot, which our party was actually able to donate to by the rules and regulations of the Department of Elections here in the Campaign Finance Division. So the fact that our bylaws specifically state that we're not allowed to endorse or donate to candidates outside of that are not running as libertarians prevents us from even participating as a political action committee in elections that we don't have 3 candidates in. And that's again another function of the reason why it's the challenge of trying to form a political party here in the state of Rhode Island.
But these candidates who are subject to this challenge, have they been endorsed by your organization?
Yes, sir. We had
Has that endorsement been filed with the Secretary of State?
Well, sir, no. Again, I challenge you to find how I can file an endorsement for a political party that does not exist. In the eyes of the Board of Elections, not in the eyes of the Secretary of State or or for that matter.
Thank you.
Thank you, Mr. Schultz.
Madam Chair.
Yes,
I
Mr.
do
DeSimone.
actually have a question. Can you just address the sufficiency issue with regard to the nomination papers submitted by Mr. Gizzarelli?
Yes, sir. I have something similar. I can certainly go through the forms. Realistically, there's similar to what the candidate Lemire was alluding to earlier. There's been a lot of inconsistency with the numbers I've been getting from the Secretary of State. I did request a copy of all completed and certified forms that they provided to me. And they did send me in a OneDrive link with 4 attachments that I was able to go through. And I counted, there was forms that were 178 forms that they had numbered as part of this. Regarding that 178 forms, 2 of those forms, specifically forms number 39 and 40, had 2 separate towns submitted forms with the same numbers. So that I believe, I can go back to my list here. Cranston had submitted duplicates for 39 and 40 for the ones that were in the ones for Portsmouth and Cumberland. So 2 forms that were supposed to be submitted for Cranston. The only reason why I even came across these forms, for your information, I had asked the Board of Elections, the Secretary of State to send me forms as soon as they were available so I could begin to start verifying them so I could prepare my challenge. And I received those copies of those specific duplicates as part of the first batch of attachments and not part of the preceding attachments.
I guess what my question is I'm asking for specific numbers of signatures that you feel qualify you beyond what was provided by the secretary or by any board. So
Mr. DeSimone,
if you just let me finish the question. So are you contending that you are entitled to some signatures that you weren't given?
Yes, sir.
Okay, and so specifically, how many?
Well, that is a number that I don't want to give an exact number for, but I have a minimum of 48 signatures that I would like to challenge, that I have voter ID numbers associated with them.
Okay, 48 signatures that were denied?
That were denied, that I would like to have
So
challenged.
you have how many signatures did you get in total?
Well,
Were considered qualified?
well, see, I would like to, again, recognize that I've not been given the same benefit of the doubt or the access to the numbers that was provided by the Secretary of State. I would
Well, see-
also.
available. See-
They
Yeah,
No,
please,
I think-
Mr.
yeah,
Mercatio, would you
okay.
please clarify?
What was initially filed by Mr. Hunt was extensive, and what I was trying to do is get motions that would narrow the scope. If the board accepts the recommended motions that I proffered, and if we are left with signatures that need to be challenged, I don't believe that Mr. Raposa has had the opportunity to prepare a list similar to what we just did for the others, and it would, I think, benefit everybody to get that done, share it with Mr. Hunt, so he can see what signatures are in play, and then convene this at the next meeting so he can have an opportunity
We
to
haven't had a
review that.
staff review, is what you're saying.
Yes.
Well, yeah, I understand that, Madam Chair. I guess my question is, you filed an objection. Your objection says, the first item says the sufficiency, specifically the insufficiency of the nomination papers submitted on behalf of Elijah Gizzarelli between July 6th and July 15th. Presumably, you've counted the number of signatures, correct?
Yes,
Okay. And some of those signatures were allowed, some were disallowed, correct?
correct.
How many were disallowed?
Well, so there's, if you read the complaint further and whether or not I'm allowed to speak on further action, portions of the complaint.
Look.
Well, but see, this is,
Okay,
with all
all
due
right.
respect, with all due
Okay,
respect,
all due respect, I just asked a question. You don't have the number, that's fine.
I do have the number. I
Okay,
do-
what's the number?
Well, so again, I have a minimum, this is a minimum number. I don't know what the maximum number is. 1,285 signatures that were submitted by us. That, again, this is not a minimum number because of, again, further my complaint,
So you submitted, your contention is you submitted 1,285 signatures.
at least. At minimum.
How many of those signatures were qualified by the state agency?
Again, without knowing what they provided me with copies that showed 919 signatures certified, but their website indicates that there's 946 signatures certified. And again, this is where the inconsistency is, that's part of further issues in my complaint.
Okay, so you have 54 additional signatures that you believe should have been included.
At least, yes, sir.
Okay. I'm just trying to narrow down what we're speaking about, because I, for one member of the board, am not going to comment on whether the state law is fair or not, whether the state law should be changed or not, whether the Secretary of State's operating procedures are to your liking. I am, for one, am not going inclined to opine on that. So whatever motions, Ray, you think we need to make to sort of narrow the issue down to this signature issue.
I think that the nomination papers is one issue, and then the other are what the other, that were
Yes,
outlined.
yes, Madam Chair. I
We have
think
two
that
separate.
the board should find that Mr. Hunt does have the standing to present the challenges relating to the nomination papers of Mr. Ghizzarelli. I have not heard anything with respect to Mr. Vecchia, and I believe that's over. As far as the nomination papers, only on the nomination papers, is that, that's clear.
Right.
And then a separate motion with respect to a lack of standing on the balance of the filing, bringing all of the allegations of challenging the statutes, challenging the processes, all of which Mr. Hunt has a right to pursue, but not in the way that he's presented to this board to date.
Relative to the complaints, not the challenge.
So
Yes, relative to the filing, that's
so
right.
I would move his standing with regard to the nomination papers and signatures of Mr. Ghizzarelli.
If I may just.
And I would, and if I may, I would second that motion and just say that in terms of immediacy, as I understand the issue, the opportunity for this party to qualify is first available to it by getting a candidate on the ballot who obtains the necessary votes in order to qualify under that section of state law. I do not think that we are qualified or required or permitted by statute to rule on the other issues concerning the process of qualifying a party, but we can rule on the issue of qualification of a person to run. And so I would second Mr. DeSimone's motion that we proceed to review the submitted signatures to see if there are enough to qualify.
On the nomination papers. So we have,
May I just?
No,
excuse me,
not
sorry.
at this point, sir.
so we have a motion and a second to allow the review of the nomination papers. Is that what the
Yeah, I mean, I moved that he does in fact.
has the
have
standing to
and
allow-
I think Mr. Macasio outlined how the
Right.
statute just provides political party. It doesn't say recognized political party. So I certainly would move to accept his standing on the nomination of Mr. Ghizzarelli.
Could we amend that and to proceed with the process of determining
Absolutely.
qualification?
Absolutely, I would agree with that.
via the staff review, correct?
Right.
So we'll have to put this
Well,
on.
yeah, but I mean, I think first and foremost, we have to decide that he has standing. So
That's correct.
That's part of the
I
motion.
would make that part of the motion.
Very good. So we have a motion and a second. Do we have any discussion or questions relative to this motion? Okay, hearing none. All in favor signify by saying aye.
Aye.
Those opposed? It's unanimous.
And then, Madam Chair, the second motion I would make would be to deny him standing on any of the additional matters related to the manner in which the state law requires elections to be conducted. I think that not only is it non-standing, I think it's a lack of jurisdiction. I think those issues on state law need to be filed either in, most likely in the federal court. I know there was several cases in the federal court in the past on these issues, some of which were brought by the Green Party and some other parties, but I think that's the proper form. I don't think we have either the authority or jurisdiction to hear those kind of claims.
So this is a denial without prejudice, Mr. DeSimone, as proposed by our,
Yeah, I mean,
Counsel?
I don't think we can deny with prejudice because I don't think we have the jurisdiction.
We don't have
So
jurisdiction.
It'd be a
Correct.
denial without prejudice.
okay, that's a motion. Do we have a second?
Second.
Seconded by Mr. Scholes. Any further discussion on the motion? Hearing none. All those in favor signify by saying aye.
Aye.
Those opposed? It's unanimous. Thank you, Mr. Hunt.
So as far as how the board wants to proceed, I don't know whether we're going to be able to determine that at this point.
With reference to the nomination
Yeah.
papers, we need the staff to review
We
and
need a
then,
review.
We need to review, and we would like to present back to you our findings on Tuesday, August 16th.
Do you, Mr. Hunt, do you have any issue with that?
To be honest with you, I don't suspect so. My wife is due on the 19th, so I can't
Oh.
promise you.
Okay, so you might have an
Yeah,
issue.
so I can't.
Well, we would certainly move it if we needed to.
I mean, is there another time constraint, Bob, that we would have to be concerned with?
I did that for the drop off to them, right? The period ends on 12, so we were doing the 16th, so we can do both at the same time.
Okay.
But we could move this item to a later agenda. No problem with that.
So, and just to clarify, so just so I understand correctly, we're going to do another review of the signatures afterwards, but the rest of the complaint you chose not to hear. correct?
Denial.
Okay, thank you.
And again, I'm only one member of the board, but what I would suggest you do, because I've had to do these in my private practice, I would suggest you get your list of signatures that you think are good signatures, have them tabulated, go over them, and go over them in light of whatever the board's staff provides to you, so that you can come to us and say, John Smith is a good signature because of this.
Understood.
Okay.
All right. Thank you very much for your time.
Thank you. So we will now go back to
Item number 7.
item number 7, Mr. Lemire. So I'm not sure, are you going to testify, sir?
Well, I think you could do two things.
If you're going to testify, we need you to be sworn. That's why I'm asking you. Okay. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I take that as an I do.
Yes, I do.
Okay?
Okay, so, let's see, I just got this, right? Obviously, I guess we could continue this till the 19th, right? So I can go through this, because, I mean, I found a couple indiscrepancies already. But to be very honest with you, I'm not going this route, okay? My main challenge here today is, right, is that we all have to go and I have to do certain things by a certain time, okay? So in Lincoln, I had 49 signatures, and in North Providence, I had 8 signatures. That they were denied with no reason, okay? They did whatever they did, okay, and that's fine. Now, he went and he went and double checked them. But that was supposed to be done by the 21st. It wasn't supposed to be done a week later or 10 days later, okay? Now, everybody else that denied my signature gave me a reason why, okay? Voter not found, voter not there long enough, okay? So by the town of Lincoln just giving me an X, okay, with no reason is not valid, okay? That signature should have been deemed valid because they had until the 21st at 4 o'clock, okay, to give a reason why. Now, he went a week later and did what he had to do. Now, all I'm saying is, let's give us a week. What I'm telling you right now, your lawyer can go and double check. But the Rhode Island Superior Court and Supreme Court have ruled that no board shall render a decision, okay, or deny a petition without a reason, okay? Now, in Universal Properties and Commerce Properties against the town of Coventry, okay, this was a case that the board denied their petition, okay? At the end, the Supreme Court said they had to come back and give a reason why they denied it, okay? Just like the town of Lincoln should have given me a reason by the 21st, but they didn't. But this is the thing, is that in Coventry, they sent it back, they gave a reason and everything. The town of Lincoln had till the 21st. They didn't make their deadline, okay? All they did was put an X there, okay? So by them not giving a reason by that time, okay, that signature should be deemed valid. They had till the 21st to tell me why they didn't want the signature, not just to put an X there. So, like I said, you can check this out. Everybody's, I'm not a lawyer. I'm just reading what I'm reading, okay? Right now, I just got this. I found a couple that I didn't like. All I can tell you is we're not 100 away. We're only 29 away now.
So you're asking this be continued to our August
I
16th
think
meeting?
what I'm asking you is to continue it, but also have your legal counsel, Ray Morocco, okay? Marachi, look up what I'm just saying, okay? And see if what I'm explaining, because obviously we're running out a little bit of time here, okay? And
May I ask a question? When the local boards look at these, are they required to put a reason on those forms as to why they do not approve those signatures?
I'll have to look at the statute. I'll have to look
I
at
don't
all I can
recall
do is
that
look at the
ever
statute.
being a
I
discussion.
don't remember seeing that in the statute. I'd have to look
well,
at
this is
it.
the thing.
Madam
With-
Chair,
But if I
could
could
ask
say,
that.
Oh, good.
I don't know
May I
how,
read-
And I just from my experience on the board, I believe there needs to be a reason, but not, it doesn't, I don't know of a requirement that requires them
Right.
to enunciate the reason to the candidate.
That's what I would guess, but go ahead.
Yeah.
Mr.
What I'll
Wells.
say, under 17-14-11, the board will check and
Mhm.
certify the signatures. That's all it says.
Yeah.
Doesn't have to give a ground
Well, this
or a
is the
reason.
thing. We can go by what that law says, right? But just remember this, the Constitution supersedes every other law that makes a mistake, okay? What, that little thing that you just read?
all right, let me just stop.
There-
Just,
there's a little discrepancy.
I don't want to get into the Constitution, but
We're
I mean,
aware.
there is an easy way to do this. Either Lincoln provides the information or you subpoena them. But
No, they
That's-
had till the 21st. to
Excuse me.
subpoena them.
Let our attorney.
the
finish,
statute
please.
says that you can subpoena any witnesses necessary
Yeah.
to obtain the information you need to make a determination. Why Lincoln just writes the X, I can't say.
Right.
I think at previous meetings, we said we're going to try to get a uniform process for rejecting and
We
accepting.
have
And
said
that,
that.
If I may,
May I ask just how many signatures Lincoln put the X on?
49, and then North Providence put 8, which would bring me well over what I need.
Oh, you're saying because they put an X, they should be good, because you didn't get a reason
The
listed.
thing is that if you read the law says that you have to give a reason why you rejected it. Now, this particular thing has a time limit to it. I had a time limit to do my things. I give you the example, but the Board of Elections, or whatever you want to say, actually was given an extra 9 days, because this guy went and he did a very good job of it, okay? I have a lot to go over, but you were actually given extra 9 days. That's incorrect. By the 21st, you should have given me a reason why that signature was no good, not given an extra 9 days to tell me why that signature was
Okay,
no good.
you've made your point, sir.
Okay.
Miguel, did you have something you'd like to say?
yes, the deadline that Mr. Lemire speaks of is, they certify those signatures to the Secretary of State, and they do so within the Central Voter Registration System. So as I mentioned at the previous meeting, that each of these lines on this document is represented in the Central Voter Registration System with a code for the reason why the signature was rejected. It could have been the signature didn't match, but for the most part, many of the rejections coded in there would be due to the voter not being in the district or the voter not being found. So that those reasons are provided within the system that is available was available to Mr. Lemire if he had requested it from the Secretary of State's office. So the reason that some boards are more specific in putting voter not found BNF, as you can see on the documents that you have there, for the other towns. However, some towns only put a check mark and an X. And as was mentioned, we've made the Secretary of State aware of this to make some improvements in the coding of that. But the actual coding of it happens within the Central Voter Registration System.
And we had that discussion at our last meeting, and that makes perfect sense for everyone to be following the same format.
Correct.
So do we have a
I would like to add
motion?
to that, please, Chairwoman.
One more comment, please.
So let's see. Mr. Rock is back there, okay? I asked him for certain stuff through the computer. During this thing, I asked to tell me specifically when the votes were put into the computer. He said he didn't have that type of knowledge, okay? That he could not find that. We know we can find it at some point, okay? But I'm just saying, is what he just said about them putting these codes in, okay? That's not public. That information was not given to me. I was not privy to that information.
Okay, you've made that point. Thank you,
Okay.
sir. Could we make a motion to refer this to our next meeting on the 16th of August?
Second.
Moved and seconded. All in favor, signify
Aye.
by saying aye. Those
Aye.
opposed, it's unanimous.
August 16th.
Correct. Thank you.
Thank you very much.
Do we have a motion to adjourn this meeting?
So moved.
Moved by Mr. Scholl, seconded by Mr. West. All in favor? We are adjourned at 3:36.
I think we saved the people last.
Lucky you.
You know, I remember.
Thank you. Yes, thank you. I appreciate that. My property professor had the same problem.
If these people are gonna represent themselves, we gotta hold them to a high standard.
Marcella, take me aside and talk about the
They're
regulations.
gonna represent themselves, we gotta hold them to a high standard.
It's been continued. Of course, you were right.
Right.
I didn't know.